So Parler's request for a temporary restraining order or a preliminary injunction against Amazon was denied. Here's why. My name is Nate the Lawyer, and welcome to my channel. If you're new here, don't forget to like this video, share this video, and subscribe to the channel if you like what you hear. Now, for all you new people out there, I lay out the facts, I explain the law, and you come to the decision. For those of you who don't know what's going on between Parler and Amazon, here's some quick background. Parler is a competitor to Twitter. It has the same type of function. Now, for Parler to work, it has to be hosted. It's hosted by Amazon. Now, Parler's claim to fame is that it's not Twitter. It's a free speech platform. It allows a little bit more what people like to call objectionable content than Twitter. An example of some of the more objectionable content that's on Parler is calls to kill Amazon CEO Jeff Bezos, for instance, calls to kill Twitter CEO and Facebook CEO, and some other really objectionable content that is on Parler. Now, the posts that, advocate for the killing of Amazon CEO obviously violated Amazon's policies against this type of content. And they were a breach of the hosting agreement between Amazon and Parler. Now, this is the first important fact that we need to understand. Parler did not deny any of these posts were abusive, or they didn't deny that they violated Amazon's policies. They did. They know that these posts violated Amazon's policies. Now, this is relevant because this is not about whether Parler breached the agreement, because they did. This is about Amazon's response to Parler's breach. So when you do have a breach of the contract, there are two pieces of the contract that are identified in this lawsuit. One, Amazon can suspend Parler immediately if it finds the conduct to be of such a nature where it says, we got to suspend you immediately. Or Amazon can allow Parler 30 days to fix the breach. So if Parler breaches, Amazon has two options. Now, in this case, Amazon chose to suspend Parler's account immediately. Now, this essentially closed Parler's business down because they were operating using Amazon systems, and Amazon said, you can't use our systems anymore because you breached our agreement. So Parler went to court initially and asked the judge to issue a temporary restraining order. Now, a temporary restraining order is an ex parte remedy, meaning that only one side, in this instance, Parler, gave its side of the story. The judge, not being too convinced about what Parler was asking for, then required Parler to notify Amazon of the action and convert this temporary restraining order into a preliminary injunction. Now, since we now have a preliminary injunction, this would allow the judge to hear from both sides before deciding the issue. So in this action, Parler alleged three things. First, an antitrust violation for a conspiracy and the restraint of trade. Second, Parler alleged that there was a breach of contract. And last but not least, Parler alleged that there was tortious interference with a business expectancy. Now, we'll take each one of these one by one. First, let's talk about the conspiracy and restraint of trade. Now, Parler alleged a conspiracy between Twitter and Amazon to harm Parler. Now, one of the legal requirements is that Parler show that there's evidence that Amazon and Twitter acted together and intentionally in the restraint of trade. Now, as proof of this, Parler made an argument. Now, you have to infer this intention from Parler's argument. So first, Parler claims that Amazon hosts Twitter. Then Parler also claims that Twitter had the same post on Twitter that Parler was suspended for. Third, Parler then alleged that Amazon had not suspended Twitter. And last, since Amazon did not suspend Twitter, this was proof of the conspiracy. I cannot say this strongly enough. Parler submitted absolutely no evidence of this agreement, of this relationship, or this reasoning. This is just their reasoning and what they said. They have submitted no proof that this is actually true. Now, in response, Amazon submitted
sworn declarations under penalty of perjury
by an Amazon executive. And it stated that Amazon doesn't host Twitter. Parler's wrong. They don't host Twitter and couldn't suspend Twitter for that conduct anyway. Second, Amazon explicitly denied any existence of any type of agreement to remove Parler by Twitter and Amazon. They say that's crazy. And again, to support their claims with evidence, they gave
sworn statements under penalty of perjury.
And Parler gave nothing. So the judge found that Parler was just factually wrong, since Amazon didn't host Twitter and couldn't suspend them for the conduct anyway. So our first question is, When it comes to the likelihood of success on the merits for this first cause of action, this conspiracy between Amazon and Twitter, Parler submitted no evidence, while Amazon submitted sworn statements under penalty of perjury and doesn't even host Twitter. So for the claim of conspiracy to restrain trade, do you think Parler has a likelihood of success on the merits? Let me know in the comment section. Next, Parler then alleged Amazon breached its contract. Now, as stated earlier, there were two provisions of the contract that dealt with breaches. One allows Parler to cure a breach within 30 days, and the other allows Amazon to suspend immediately. Now, it can't be understated. Parler does not deny that they were in breach of the agreement. They don't deny that. What they want is that Amazon used only the provision that allows them to cure the breach and not the provision that allows them to suspend immediately. That's Parler's argument. Even though we agree we are in breach. This reminds me back when I was an officer. This happens a lot of the time. And I'll give an example. Speeding tickets, right? Let's say someone is going 30 miles an hour over the speed limit. That driver can be arrested, ticketed, or we can give them a warning, right? Hey, you know what? Just don't do it next time. So those are the three options available to the officer. So if a driver, Parler, admits that, hey, yes, I was speeding 30 miles an hour over the speed limit, and Amazon says, well, who is the cop in this instance would say, well, I'm going to arrest you. Or even if Amazon says, I'm going to give you a ticket, Parler can't then go to court and complain that they should have gotten a warning, right? And I know some people are arguing that this makes warnings obsolete, but no, this doesn't make a warning obsolete. The officer could do one of these three things because you're in violation and they chose one of the three options. Just because you don't like the option they chose doesn't mean that that's an invalid option. So essentially, that's what Parler was asking for. But the judge found that Amazon had the right to handle the breach in a couple of different ways, and it chose to suspend Parler. Now, I know what you might be thinking. Well, what about the argument about Twitter? Twitter has the same conduct. Amazon didn't suspend Twitter. But remember, Amazon doesn't host Twitter. So Amazon couldn't suspend Twitter even if it wanted to. Now, let's talk about the last claim, intentional interference with business expectancy. Parler had to show that Amazon breached the contract. But remember, Parler doesn't deny that Parler breached the agreement. Parler doesn't say, we didn't breach the agreement. They admit they breached the agreement. Now, Amazon responded to the breach by exercising its rights under the contract to either suspend immediately or allow 30 days to cure. And again, Parler didn't deny Amazon had the right to suspend them. At the end of the day, the court looked at it and said, Parler's arguments are bullshit. And the motion for a preliminary injunction is denied because you got no proof, you got no evidence, and your arguments are shit. Now, if you're on the right, you think this ruling is junk, and if you're on the left, you think this is a good ruling. But if you look at the basis of law, this decision is an appropriate decision based on the arguments presented to the court. So at the end of the day, what did you think? Did the judge get it right? Let me know how you feel. Do you think the judge should have issued this preliminary injunction or not? My name is Nate, lawyer, YouTuber. I'm out.